Hey, welcome everybody to today's impromptu episode of the Law of Self-Defense. I am, of course, attorney Anna Branca for the Law of Self-Defense, if anybody can hear that. And we are, yeah, it's not my little applause button doesn't work anymore. I'll have to get that fixed. So we are here to talk today about this opening statement analysis. A legal analysis of the opening statements from a couple days ago. We've had the first 2 days of the Hannah Gutierrez trial, a whole bunch of witnesses. And I think it's always worthwhile to kind of document in a summarized, analyzed form what promises were made by the state and by the defense in their opening statement, so that when we're listening to the testimony, when we're listening to the evidence as it comes in piecemeal over the course of a 2-week trial, we can put it into context. Where does this piece of evidence fit into the arguments they promised to convince us of? So that's what we'll be doing today. And we'll be doing that. I'll be sharing that in the form of, why is that not working? That worked. That worked. Okay. We'll be doing this in the form of, I made a bunch of notes for myself. And I typed these up as PDF documents. So here's the state opening analysis. It's about 5 pages long. And here is the defense opening analysis. It's about 5 pages long. Both these PDF documents will be embedded in the replay version of today's show for Law of Self-Defense members only. So Law of Self-Defense members, when you access the Law of Self-Defense blog, you access this replay of today's show, you'll be able to downlink these two if you'd like them for reference or for your records moving forward. The good news, folks, is that it's dirt cheap to be a Law of Self-Defense member. It's only 99 cents to get these kind of benefits. Plus, Law of Self-Defense members are the only places where we answer questions and comments as SOP, and they get transcripts of every show. Or at least shows where a transcript would be relevant, and much, much more. So you might consider becoming a Law of Self-Defense member. You can do it for just 99 cents for a 2-week trial membership. 99 cents, and that'll cover you for the whole duration of this Hannah Gutierrez trial. And you'll be able to get all your comments and questions answered for free as a Law of Self-Defense member after the 2-week trial, which you can access at lawofselfdefense.com/trial. Simple enough. You can do that right now. Open up another tab in your browser, go to lawofselfdefense.com/trial, sign up for the 99-cent 2-week trial. You'll be emailed instructions immediately for how to access today's show and all the other members only stuff we do. After the 2-week trial, if you stay a member, and just about everybody does, it's still dirt cheap. It's only about 30 cents a day, less than $10 a month to be a Law of Self-Defense member, but you owe it to yourself to at least try it for 99 cents. I mean, how can you go wrong for just 99 cents? So we've had the first 2 days of the Hannah Gutierrez trial, Thursday and Friday. Monday is the third day, full day of proceedings. And on Thursday, of course, we had our opening statements by the state and by the defense. And that's what I want to go over here today. So, of course, recordings of the video of the statements is available as content we covered on Thursday. But if you don't want to listen for half an hour to each one of those openings, and of course, this way I can do it in a summarized fashion and with my own thoughts and comments on what they were arguing. So I do want to make this a short show because it is, of course, Saturday, and I'm sure we all have stuff to do. Let me just pin the Twitter stream. It's kind of a pain. They make me do that separately. And see if Rumble has decided to work today. Yes, and let's go right into it with the analysis of the state's opening statement. I'll make that bigger. I'll make me smaller. I wonder if I have to be quite that small. Maybe that's a little better. Whoops, that's not what I wanted to do. I wanted to make this larger. All right. So the Hannah Gutierrez, the armorer trial from the movie Rust, state opening analysis. This was given by the special prosecutor Jason J. Lewis. I thought he presented very poorly in terms of presentation style. Not a good speaker, very low energy. But here we're just going to speak to the merits of what he talked about. And when I say I've summarized your opening statements, I've also reordered portions of it so it makes more logical sense. That's in some instances they were speaking in kind of a scattered manner, speaking to a point of argument and then moving on to something else and then circling back. So this is not a linear representation of their closings. If you want their precise closings, again, the videos are available. I've already covered that. So Prosecutor Lewis starts with the two charges against Hannah Gutierrez: involuntary manslaughter and tampering with evidence. And then I'll provide some background that he included. So he starts off by saying that armorer Gutierrez was responsible for sourcing and bringing all the firearms as well as the dummy and blank rounds to the set. In fact, and this is me speaking now, in fact, that's not true. Gutierrez's primary job was as armorer, but she had a secondary subordinate props role under the supervision of the head of props, Sarah Zachary. Sarah Zachary was an employee of PDQ props, and it was PDQ props, not Gutierrez, that provided the bulk of ammo and guns used as props on the set, maybe all of it. Now, it is possible, in fairness, that Prosecutor Lewis may have meant that Gutierrez was responsible for bringing all the firearms as well as the ammo to any given scene. That would be true, but that's a different matter. And the law demands precision of language. And it's important because one of the key questions in this case is who brought the ammo to the set, not just to a scene, but to the set. Why was there live ammo on the set at all? So a little more background on what we're talking about in terms of ammo. So we have a live round of ammo. That's a normal functioning bullet. It consists of 4 components. It's got a brass case, it's got a bullet, it's got a primer, and it has gunpowder inside it. Fully complete cartridge with a bullet. A normal cartridge should never be on a movie set for obvious reasons. Then we have a blank round. A blank round is an almost complete cartridge. It's all the components of a cartridge, but for the bullet. So it still has a brass case, it still has gunpowder, it still has a primer, but instead of a bullet, it's crimped or squeezed closed at the place where the bullet would be, the case mouth. And when it's fired, it creates a flash and smoke because the gunpowder combusts, but there's no projectile that comes out, no lead projectile anyway. There will, of course, be unburned powder, and there may be a little bit of wadding or something like that, but nothing that in the normal course of events ought to be an imminent deadly force threat. I mean, I wouldn't want to hold one to my head, but they're intended to make noise and flash as opposed to fire or projectile. Now, because they are crimped at the end where the bullet is, if you visually inspect a blank round, it's pretty apparent that it's not a live round. There is no bullet. It's squeezed shut at the end. So it's easily distinguishable by a bullet simply by visual inspection. But to see the front end of the bullet, obviously it can't be inserted like into the chamber of a semi-automatic firearm because you wouldn't be able to see the case mouth. So you wouldn't be able to tell if there's a bullet or if it's crimped. But if you're holding the bullet outside of the firearm, it's readily identifiable as a blank round as opposed to a live round. Then we have dummy rounds. Dummy rounds are completely inert. They don't fire at all. There's no gunpowder in them. Often there's no primer. That's one way to make a dummy round, is not have a primer. If you don't have a primer, even if there's gunpowder, there's no way to ignite the gunpowder because the primer is what ignites the gunpowder. But you make a dummy round and it has a case, it has a bullet. It may have a spent primer in it, but you make a dummy round and you make it identifiable as a dummy round by either drilling a hole through the side of the case or by putting ball bearings or little springs inside the empty case so that if it's rattled, you can hear them bouncing around. Live rounds don't make a rattling sound. You may be able to hear a soft swishing sound of the gunpowder moving around, but it sounds quite different. Or you just don't have a primer in the cartridge. So those are visually and or audibly distinguishable from a live round if they're inspected. That's how that would be done. So now, again, it may be necessary to take it out of the firearm to do that, right? To see if it's chambered, you won't be able to see the hole in the case, and you won't be able to shake it and hear the springs. If it has no primer, in theory, with a revolver, you could just look at the rear of the case and see that there's no primer, and you'd know it was a dummy round. So precisely how you would identify it's a dummy depends upon the nature of how it was manufactured. Now, a standard operating procedure for checking of a firearm on a movie set is generally speaking as follows. So the armorer, and here that would be Hannah Gutierrez, checks the firearm to ensure it's in the desired condition. So the gun could be in different conditions for different purposes on the set. It may be fully empty, so there's nothing in the chambers. It could be loaded with dummy rounds for presentation, as if it were loaded in a real gun for credibility, realistic use of the gun on the set. It could be loaded with blank rounds, so it'll discharge the blank rounds. It'll make smoke and flash. But obviously, on a movie set, it should never have a live round in it. There's no reason to have a live round in a gun in a movie set. But the specific condition you want the gun in could be different depending if it was a rehearsal or a live shot and what you wanted the gun to be able to present as during the live shot. Now, if blank rounds were intended, each round should be visually confirmed to have a crimp at the case mouth and not an actual bullet. That's how you make certain the safety of the blank round, that it's a blank round and not a live round. If dummy rounds are intended, so nothing is supposed to ignite, each round should be visually or audibly confirmed to have either a hole drilled through it or the rattling sound from the bearings or the springs or a missing primer. Once this is done by the armorer presents the firearm to the assistant director for independent inspection. Now, they don't normally hand the gun to the assistant director for the assistant director to walk off with it, to give it to the actor. The armorer stays in control and possession of the firearm in this process, but she presents it to the assistant director, so you have a redundant inspection step. He's supposed to do all the same things. And then the armorer offers the actor receiving the gun an opportunity to have the gun inspected in their presence, do it all again in their presence. That's SOP for safety on a movie set. Now, let's get to the criminal charges and the arguments here. Involuntary manslaughter. So for involuntary manslaughter, the state phrases this as really asking two questions. What events led to the death of Hutchins, Halyna Hutchins, and how did live ammo get on the set? For the first of those, what events led to the death of Hutchins? More specifically, because of course this is a criminal prosecution, how are Gutierrez's negligent failures responsible for Hutchins' death? What did she fail to do that led directly, proximately, to the death of Halyna Hutchins? And the state's answer here, what they're claiming is the case, what they're trying to convince the jury of, is that her failure to conduct adequate safety inspection of the revolver that was made available to Baldwin. They argue that Gutierrez did not always follow the safety standard operating procedure. She often rushed through it or she skipped it entirely. The state argues that on the day of October 21st, Alec Baldwin was to be filmed in a church scene, and rehearsal was at the blocking stage that morning. Blocking stage is a very rough kind of rehearsal. They're just moving the actors' bodies from one spot to another spot, basically to make sure they got the shots right, the lighting looks good, there's nothing that they didn't see that people are going to trip over, stuff like that. It's not a full-blown rehearsal. It's almost a pre-rehearsal stage prior to the true rehearsal, prior to the actual filming. And the truth is, for blocking rehearsal, you don't need the actual gun. You don't need the costumes. You just need the actors moving from spot to spot, from mark to mark, as they would be during the true rehearsal and the true filming. Nevertheless, Gutierrez was asked to provide Baldwin with a live gun for this blocking stage, blocking rehearsal, loaded with dummy rounds. Now, of course, we know in truth, at least one round was a live round, but it was supposed to be loaded with dummy rounds. That's what was requested. And Gutierrez loaded the 6-shot revolver to be used by Baldwin with 5 rounds. Now, it's indicated during the opening that the 6th chamber, because it's a 6-shot revolver, it may have been fouled, or there was some reason she couldn't load the 6th round at this time for the morning rehearsal. So the gun was presented to the morning rehearsal with 5 rounds in it instead of 6. So then lunch was called at the end of the morning rehearsal. Gutierrez collected the pistol from Baldwin, cleaned the fouled 6th chamber, and loaded a 6th, again, purportedly dummy round. Obviously, at least one of these 6 rounds was, in fact, a live round that killed Halyna Hutchins and wounded director Joel Souza. So after lunch, the blocking rehearsal was to continue. Gutierrez, after lunch, retrieved the pistol, now fully loaded with 6 purportedly dummy rounds. She took the firearm to the church, handed the pistol to the first assistant director, who was David Halls. Gutierrez and Halls, according to the state, did a sloppy and incomplete safety check of the gun. The rounds were not, as per SOP, visually and or audibly confirmed to be blank rounds. Obviously, we know this because ultimately a live round was fired out of the gun. Instead, the loading gate of the revolver was opened. So for those who don't know, a single action revolver of this type, if you're looking at it from the rear, of course, it's got a round cylinder shape at the back above the handle, and there's the hammer there. But on the right side of that cylinder shape, there's a little door that can be swung open. That's how rounds are put into the cylinder and how cases and rounds are removed from the cylinder. If you open up that gate, you can pull the hammer halfway back and just spin the cylinder. It'll free spin. So you can visually inspect the back of each cartridge very, very quickly. Now, that might be helpful. That might be sufficient to determine dummy rounds if the dummy rounds are of the type where they don't have a primer, because you can easily visually see that there's no primer in those 6 rounds. If it's a dummy round where an alternative method was used to flag it as dummy, the hole through the side or the springs inside, then it would need to be removed by the gun from the cylinder in order to determine that. We know that didn't happen here. Again, because we know there was a live round in the gun. So state witnesses will test. So instead, the loading gate of the revolver was open. That little door is called the loading gate. And Mr. Halls was shown a few of the rounds resting within the cylinder. The state tells us that their witnesses will testify that when Gutierrez retrieved the revolver after lunch, she should have then done a complete ammo check with Halls, removing the ammo to visually, audibly inspect, because this double redundancy helps prevent exactly these kinds of unintended killings. And that's true. There's no question about that in my mind. So there are ways in which I'm sympathetic to Hannah Gutierrez here. There are arguments for the defense to make. We'll go over those in a moment. But I'm generally zero tolerance when it comes to gun safety. So this obviously should have been done, this check. Now, state witnesses will testify Gutierrez regularly failed to properly carry out her duties as armorer with sloppy and unprofessional conduct, routinely leaving guns and ammunition lying around unattended and leaving her gun safe and ammo cart in a disorganized state. Now, when I read this, I have 2 questions. One is, well, David Halls was interviewed about her after the shooting, and he said she did a good job. So he wasn't the person complaining about all this. Second, if people were observing this conduct, and I'm not saying it's not true, I've seen her ammo cart, and I've seen the props truck where stuff was stored for her purposes, and it was a mess. The whole thing was completely disorganized. So I can easily believe it was sloppy, but if it was sloppy and unprofessional, why was she still on the set? Why wasn't she fired? I mean, wouldn't that be the responsibility of the people who were observing this sloppy and unprofessional conduct, knowing the risks involved? Everybody knows, by the way, that these are real guns. We call them props, but they're not props like inert rubber guns. Everyone knows these are fully functioning firearms. So after this cursory post-lunch inspection with Halls, Halls then handed the gun over to Baldwin. Baldwin never inspected it at all. And while manipulating the gun during the blocking rehearsal, that's when he shot and killed Hutchins and wounded Joel Souza. So the question, how are Gutierrez's negligent failures responsible for Hutchins' death? This is it. That's what we just discussed. Again, the answer is Gutierrez's failure to conduct adequate safety inspection of the revolver and its ammo, of course, that was made available to Baldwin. That's what the state says they're going to prove to the jury beyond a reasonable doubt. The second grounds for negligence is the ammo on the set. And to get to that, we have to ask, how did the ammo get on the set? So the question would be, how are Gutierrez's negligent acts, not negligent failures, not things she failed to do per se, but things she did, acts of commission as opposed to acts of omission. Negligent acts she did responsible for live ammo being on the set. The state argues that she brought the live ammo to the set and allowed it to be intermingled with dummy ammo on the set. So Gutierrez identified a particular ammo box from which she was loading Baldwin's revolver. There's a specific box that she was loading Baldwin's revolver with that was only supposed to contain inert dummy rounds. Obviously, it wasn't supposed to have live ammo. She was loading Baldwin's gun. When that ammo box was inspected at the sheriff's office by crime scene technician, of the 37 cartridges in the box, 36 had a brass primer and were confirmed to be dummy rounds. So a real bullet, of course, if you look at it from the rear, it's circular, outside circumference. And then there's a little circle in the middle for a centerfire cartridge like this one here. That little circle is the primer. That's what the hammer hits, that flashes and ignites the gunpowder inside. And they typically either brass in color or nickel, silver in color. So of these 37 rounds, 36 had a brass primer, and they were all confirmed to be dummy rounds. But one of them, of the 37, had a nickel primer. And that cartridge was found to be a live round. And this is the only image I'll show, but there were lots of images shown so far in the trial. This is the ammo from the box that Hannah Gutierrez was using to load Baldwin's rifle, and there's a live round in it. And it has a silver primer. Now, one thing the state's arguing here, will argue throughout their opening and throughout the case so far, is that a nickel primer like this one, which is a live round, if there's a nickel primer, that means it's a live round. That's what the state is trying to tell the jury. Unfortunately, it turns out that's not true. That a nickel primer is a definite identifier for a live round, distinguishing it from a dummy round. Because, as we'll see later, there were dummy rounds found on set with nickel primers. So nickel primers were present in both live rounds and dummy rounds. This will become relevant later. Another 5 live rounds were later found on the set. So for a total of 6 live rounds were found on the set. All 6 live rounds had a shiny brass case without patina. The dummy rounds tended to have a weathered or patinaed brass case as opposed to shiny. And all the live rounds had a head stamp with Starline brass of the Starline Brass Company. So the head stamp is a star, a little curved line, and another star. Starline is a company well known for making pistol and rifle brass. Now, again, I just mentioned this, but it's important to know that at least 17 rounds were found on set that were dummy rounds that had nickel primers. So it's demonstrably untrue for the state to say that nickel primers were always live rounds, even though that's what the state is saying. Demonstrably untrue. And this is important here because the state says in reviewing photos and videos from the days prior to October 21st, the day of the shooting, the state identified a bunch of instances from even the first day of filming in which cartridges with silver primers and shiny brass were spotted in gun belts and bandoliers used by actors. They say a photograph of Baldwin's bandolier worn on October 21st shows a live round. They call it a live round. A photograph of a black belt worn by another cast member also showed a live round. They even found a photo in which a live round was sitting in the lap of Gutierrez, and she failed to identify it. Now, again, what they're describing here, they're trying to suggest that all of these live rounds were objectively determined to be live rounds. I don't believe that's the case. I believe the state is simply making an inference from its false hypothesis that anytime there's a nickel primer, that means it's a live round. And we have photos of other nickel primers. So we're making the inference that those are live rounds. But I don't think that's been absolutely determined. I don't think those bullets were pulled and gunpowder was found inside. Certainly the state didn't say they had done that. So I think it's a very questionable inference, especially given that we know there were also dummy rounds with nickel primers as well. And they're making a big deal out of this, in part because some of these photos with the nickel primer rounds were taken on October 10th, at which point the only ammo on set was some ammo provided by Gutierrez. Most of the guns and ammos were provided from another source, PDQ Props, but that stuff apparently didn't arrive until October 12th, 2 days after some of these photos were taken. But again, this is only relevant if you buy the state's argument that nickel primer automatically means live round. But that's demonstrably not the case, because dummy rounds with nickel primers were found on the set. The state continues, another reason to believe that Gutierrez brought live rounds from her home in California into New Mexico to the set is that the box of ammo she used the day of the shooting, the one she loaded Baldwin's gun with, the one that did have a live round in it, at least when investigated at the sheriff's office, is marked with the letters JS, little tiny letters JS on the end. And we know from text messages, the state knows, text message exchanges with her father, the famous Hollywood armorer Thel Reed, that he possessed identically marked ammo boxes with the little JS. So the state's trying to say, well, we know the ammo in that JS box on the set that had the live round that she was using to load Baldwin's gun. We know that she brought that from her dad's place in California because we know her dad had an identical looking box with the little JS on it. But here it's important to note, and this is, the state's going to get exposed on this, that Thel Reed had recently worked with Seth Kenny, the owner of PDQ Props, who provided the bulk of guns and ammo for the set. The two men had worked together. They knew each other. Thel Reed had worked with Seth Kenny on a different set to do live fire training for a different production, Yellowstone 1883, another Western, some months earlier. And Thel Reed had brought his own 45 long Colt ammo to that live fire training. Now, this is not a movie set. This is a gun range where they take actors too so they can experience shooting actual guns with actual bullets. You're supposed to have live ammo there. That's fine. So Thel Reed had brought his own long Colt ammo, live ammo. Some of that ammo would end up going home with Seth Kenny. It was found in Seth Kenny's property. So any Thel Reed live 45 long Colt ammo that he owned could easily have arrived at the Rust set from PDQ Props rather than from Thel Reed via Hannah Gutierrez. But this is the state's argument. So how are Gutierrez's negligent acts? What did she do wrong negligently that makes her responsible for live ammo being on the set? The state says she brought the live ammo to the set and allowed it to be intermingled with the dummy ammo. And then there's the final charge here. This is the tampering with evidence charge. So after her police interview on the day of the shooting, Gutierrez returned to her hotel room where she was visited by another cast member to see if she was okay. Gutierrez handed that visitor a small plastic bag containing white powder and asked it to hold it for her. The visitor believed the powder to be cocaine and promptly disposed of it. And Gutierrez would, in following weeks, make several efforts to recover this bag of powder. Now, the bag of powder was never in the possession of police. It's never been tested. We can't definitely know that it was cocaine. Can you make the inference that it was cocaine? Well, we know Gutierrez is a recreational drug user. People generally don't spend weeks trying to get back a bag of confectionery sugar or even carry that kind of stuff around. So you could make an inference that it's cocaine. The jury will be free to do that. Of course, the state will have to prove that to the jury's satisfaction beyond a reasonable doubt, but you're allowed to do that from circumstantial evidence, and this is the circumstantial evidence. And the state's arguing that we believe it was cocaine, will convince you of that, and that Gutierrez wished to conceal the presence of cocaine from investigators to avoid the investigators arguing that it allowed for an inference that she was drug impaired, and that may have contributed to her criminal recklessness in this case. Now, interesting thing here, the penalty on these facts for the tampering charge is up to 18 months in prison. The penalty for the manslaughter is up to 18 months in prison. Now, if she's convicted of both, they would just run concurrently. So it's still 18 months. But you might think that what if she's acquitted on the manslaughter charge? Well, surely then she can't be convicted of the tampering charge. The tampering the alleged tampering is to avoid conviction for manslaughter. But if she's acquitted at trial on manslaughter, that means she didn't commit the manslaughter. So how could you have the tampering? But it's not uncommon for courts to say if you're charged with obstruction, the investigation of a crime, or you're charged with tampering of evidence in the investigation of a crime, even if you're acquitted of the crime, you still obstructed and you still tampered. So with this second charge, it's quite possible the jury could conclude that they don't believe she's guilty beyond a reasonable doubt of manslaughter, but they do believe she's guilty of tampering with evidence because they believe that bag was cocaine, and they believe that's why she got rid of it, so the police wouldn't find it on her and think she was impaired, argue she was impaired. So Hannah Gutierrez Reeds could end up with the maximum of 18 months in prison, having been acquitted of manslaughter and convicted only of this tampering charge. So there you go. So the state's conclusion, their concluding line, this is quoting the state now. In police interviews the day after the shooting, Gutierrez concluded by telling investigative officers, quote, I don't know. I wish I would have checked it more, close quote. And the prosecutor said, so do we. All right. So next we have the defense summary. I'll make that a little bit bigger as well. Let me take a quick look and see if we have, before we do that, go back to the state. Let me see if we have comments from Jono. By the way, again, we only take questions from Law Self-Defense members on the member chat. You can become a member for just 99 cents, folks. 99 cents. And then I'll answer all your questions, address your comments for free on the Law Self-Defense member dashboard, which is what I'm reading off of now, the chat there for the live stream. You can take advantage of that at lawselfdefense.com/trial and join us immediately. So member Jono asked, doesn't a blank round have a paper wadding? Many years ago, actor John Hexum killed himself playing Russian roulette with a pistol loaded with a blank round. He shot the wadding through his temple. I don't know for a fact that that's the case, but I've never opened up a blank round. I've shot blank rounds, and of course I've handled them. And the way they're crimped, I would think if there was no wadding, the powder would just run out. The crimp is not really a tight seal of the brass. So I expect there is wadding. Even without the wadding, just the rapidly expanding gas and the unburnt powder. Sure, if you were to hold that to your head, I could easily see how it could kill you. There's the Brandon Lee case where they fired a blank, but there was apparently an obstruction in the gun. I think a previous discharge may have been a squib. A squib is when you don't get the full power of the gunpowder. Often there's no gunpowder, there's just a primer, which gives the bullet just enough energy to leave the case and get lodged in the barrel. And then if you fire a second full power load behind that, or even if you fire another blank behind it, the blank could provide enough power to force the projectile out of the barrel, much like a live cartridge. I believe that's what killed Brandon Lee. There was a bullet obstruction in the barrel. They fired a blank like they were intending to do without knowing there was an obstruction, and the bullet came out and killed Brandon Lee. So I don't know if primers have a paper wad, but it wouldn't surprise me. In any case, they're still dangerous. And of course, this is not a blank round case here, right? It was supposed to be a dummy for sure. It was not supposed to be a blank. So the question is, how'd you get a live round instead of a dummy round? Not a live round instead of a blank round. Kyle says, my 45 AC brass ball all have primers, the Hornady defensive nickel. Yeah, and these dummy rounds are almost certainly, hand loaded. I mean, that's how I would do it. And you can buy either brass or nickel primers by the thousand. That's how I bought them when I was reloading for competition. Michael says, the state did not drug test her after the shooting. That's a problem for me. I don't think the state had a reason to drug test her. I mean, she didn't fire the shot, right? So first they have to, how much of a role would impairment play? They have to kind of get there. They didn't know the story about handing the cocaine bag over to the other crew member until weeks later. Then they tried to drug test her, but the defense objected and the judge wouldn't allow it because a drug test at that late date wouldn't really be relevant to her condition at the time of the shooting. Kyle says, I'm wondering why the whole lot wasn't tested for narcotics. That's routine down here. Well, listen, some of you may remember the Dean Cummings trial. This is the world famous skier who was going to buy some land in New Mexico, and the landowner let him stay on the property. And they ended up in a fight, and the skier killed the landowner and was charged with murder, killed him with an AR rifle. Charged with murder, claimed self-defense. I think he sat in prison for like a year or 3 years. It was during COVID. And the trial finally happened. By the way, the special prosecutor in this case, Carrie Morrissey, was one of Dean Cummings' defense attorneys. She was great in that case. And she's been very good in this case on the prosecution side. But if you watch that case, you saw these New Mexico law enforcement officers, and they were all terrible. Without exception, they were awful. And I'm not sure we can expect any more from these guys. So far, they're hardly impressive. Let's see. Yesterday, Baldwin's interview, he mentioned during Baldwin's interview this would be the police interview from the same day as the shooting. I played a playback of it yesterday during lunch. He mentioned Hannah wearing a fanny pack and using that to keep ammo of various types. I've not heard any talk about it as evidence. Yes, it's in evidence. There were photos of it. Maybe those were after lunch, but there were photos of it in yesterday's testimony. Let's see. Kyle says, Brandon Lee's death was due to the previous use of well-worn dummies. One dummy left the bullet behind and the blank propelled it. Yeah, that sounds like it could happen. Bullets can fall out of cartridges, folks. The brass case mouth has to be crimped, tightened around the bullet to retain the bullet. And if the crimp can come loose, and sometimes you can just pull the bullet off with your fingers and pour the gunpowder out, or sometimes the bullet can just fall out. All right, so let's go now to the defense summary. Those were all the questions I had in the member chat. All right. So defense counsel Jason Bowles. Bowles is an interesting guy. I don't have a good feeling about him yet. Some defense lawyers are just low key, and I thought that might be him at first. I thought he did a slightly better job on opening than did the state. But there are some interesting motions filed pre-trial in this case that do not put Jason Bowles in a very good light. And he's not been super impressive to me the first 2 days of this trial. So we'll have to see how things develop. But more to his opening statement for the defense. So he said Hutchins' death is, of course, a tragedy, but not every tragedy is a crime. And even if this one is a crime, it's not the crime of Gutierrez. So, of course, he's trying to point the finger at Baldwin, who fired the shot. He said both the Rust production and the state prosecutors have sought from a very early on to make Gutierrez the scapegoat in this tragedy, to throw her under the bus to save themselves. This tragedy, he says, is instead the result of several unconnected, independent events. The ultimate event that caused Hutchins' death was Alec Baldwin pointing his revolver, knowing it to be a real firearm, at Hutchins and firing it. And that has nothing to do with Gutierrez. So I'm surprised he didn't use the words here, but what he's really arguing is a legal doctrine called intervening cause. So even if I did something that contributed to a chain of events that had a bad outcome, if there was a later, unpredictable, unforeseeable event, absent which the bad thing could not have happened, that's an intervening cause that relieves me of liability. And I will expect the defense to make that legal argument in this case. Whatever Hannah did wrong with the ammo, but for the unforeseeable fact that Alec Baldwin pointed the gun straight at Halyna Hutchins and fired it at her, Halyna Hutchins would not be dead. There would be no manslaughter here. So that's an unforeseeable intervening cause. Why is it unforeseeable? Well, there's a bunch of reasons, but one of them is that Alec Baldwin's been in something like 75 movies, lots of training with firearms, and the Screen Actors Guild, the SAG/AFTRA safety guidelines in place for decades prohibit actors from directly pointing a real gun at another actor or crew member, precisely for this reason. So because of that rule, and in the relying reasonably on the belief that Alec Baldwin would follow the rules, it was unforeseeable that he would do something so much in violation of the rules. not ensure himself the gun was loaded, pointing the gun at another actor or crew member and discharging the weapon. And therefore, it should qualify as an intervening cause that relieves Hannah Gutierrez of legal liability here. So in bold here, I've kind of bolded. I had to reorganize the opening statement of the defense to make this reasonable, but I've bolded what I think are their key arguments here. One of their key arguments is that Gutierrez was essentially powerless, was weak, was naive, 24 years old, and is being made a scapegoat for the fault of others. So the defense claims, Gutierrez is being made the scapegoat for deliberate errors and mistakes by the Rust production. She was merely 24 years old at the time. She was compelled by the production to split her time between being the head armorer and also working as a subordinate in the props department. This was only her second head armorer job. Defense witnesses, firearms experts will tell the jury that it is inadvisable to have a part-time armorer on a movie with so many guns involved. A terrible idea, the experts will say. Gutierrez was the least powerful person on that set. The production put her in that position. Alec Baldwin, who fired the fatal shot, was one of the lead producers, the head actor. He's the person with the most power and control on that set. And Gutierrez could see that there were problems, and she tried to mitigate these dangerous circumstances. She asked the production for more of her time to be allocated to her armorer duties instead of prop duties, and they refused. The production did not allow her to place the necessary emphasis on her armorer duties. Now, many people will say that if she didn't feel she had the time and authority to ensure the safety that her armorer position made her duty, she should have quit. And I agree. Strictly speaking, that's true. But it's also true that a jury might be sympathetic to the notion that it's hard to do that, just up and quit, when you're a 24-year-old on your second gig as an armorer, trying to build the foundation of a reputation. How do you get another job as an armorer in Hollywood if you just walk off the set of your second gig as a head armorer? What can I say? I don't think you should take the job unless you're willing to walk off the job if it's unsafe, but a jury might be more sympathetic. The defense continues, the production did not provide Gutierrez with sufficient time to adequately inventory all the ammo on set. Now, there were hundreds, maybe a couple thousand rounds of ammo on set, presumably no live rounds, although we know now that there were, but dummy rounds and blank rounds. And the defense is trying to suggest that, hey, Gutierrez should have been given time to look at every single one of those. That was never going to happen, especially on a low-budget film like this. The reason everything was so rushed on set, so many corners cut, the reason they had an armorer where she'd only had one job before this one as a head armorer, 24 years old, was because they had a low budget. And a low budget means also very little time to be on set. So they had to do everything quickly. They were never going to take time for her to go through 1,000 rounds of ammo and inspect every round. In any case, I think it's kind of a weak argument. First of all, the defense doesn't say she requested the time to do that, which would matter. Why would they provide it if she didn't request it? Second of all, I don't think you really have to look at all the thousands of rounds. Every day, a certain number of rounds are going to be required. So when your feet hit the ground on the set, I would start inspecting ammo. And the ones I inspected and were safe, I would put in one pile. And I would only draw from that pile for use by the actors. And then whenever I had a lunch break or whatever, I would inspect a few more and add them to the inspected pile. That's how I would do it. But in any case, the argument of the defense here is basically the production put her in a position to fail, and sure enough, failure results. Is that really her problem, or is that the production's fault? The next main argument they make is about these OSHA safety violations. They're trying to suggest a general lack of safety on the set, and that general lack of safety was a responsibility of the producers. So the defense says they're going to hear from OSHA, which of course is a worker safety agency. In this case, it's a New Mexico state level worker safety agency. that inspected the set after the shooting happened and found many safety faults on the set, to the extent that they levied the largest OSHA fine, safety fine, in New Mexico history against this production. And that fine wasn't against Gutierrez. It was against the production. And OSHA noted part of the basis for this enormous fine was that the production, Gutierrez was rushed and overworked by the production, and that assistant director David Halls failed to address prior safety issues, including 2 accidental discharges with blanks that occurred just 5 days before the Hutchins shooting. Halls did not provide daily safety briefings as required by SAG-AFTRA, and Baldwin himself was provided no particularized safety briefing before rehearsing the church scene with an actual firearm in which he shot Halyna Hutchins. Now, I have to say, in a sense, you have these accidental discharges. If David Halls had said, hey, I'm going to pause everything for a couple hours, I want everyone, all the actors, to get additional training to avoid accidental discharges, that would not have prevented the shooting of Halyna Hutchins, because that wasn't a function of an accidental discharge. On the other hand, maybe you could argue the training against accidental discharge would do things like emphasize finger off trigger, right? So fair enough. I'm rethinking this point now. It depends on, that's true in the context of Alec Baldwin. It would have relevancy. In terms of Halyna Hutchins, in terms of Hannah Gutierrez, this argument doesn't really have relevancy, because her wrong was not the trigger press. Her wrong was failure to inspect the ammo properly, allegedly. And therefore, training on accidental discharges does nothing to optimize inspection of ammo. All right, the next major argument by the defense here is pointing at safety violations by the production and by Baldwin. And these are more focused on gun management as opposed to the OSHA violations, which were more general. The defense argues the rehearsal in the church was a blocking rehearsal. I've already talked about that. No gun was required for a blocking rehearsal. But Gutierrez was ordered by her superior, her boss, the first assistant director, David Halls, to hand him a revolver for Baldwin's use. And she obeyed that order. David Halls is an experienced director, I guess assistant director, and knows full well that no assistant director should be handling a firearm between the armorer and the actor. They might observe the firearm being inspected by the armorer. The armorer may demonstrate to the assistant director that it's empty, or it's only got blanks, or it's only got dummies, but they're not supposed to handle the firearm. Now, having wrongfully inserted himself into the handling, because he does take the gun from Gutierrez and bring it into the church and hand it to Baldwin, he failed himself to adequately inspect it. And when he handed it to Baldwin, Baldwin did not inspect the firearm at all. And David Hall's decisions and Alec Baldwin's decisions are not within the control of Gutierrez. They're the powerful people on the set. She's the least powerful person on the set. Also, it's a fundamental rule of SAG-AFTRA and common sense that actors are not allowed to point real guns at other actors or crew, which is obviously what Baldwin did. In fact, there's a bunch of gun safety rules all gun owners learn, and they tell us this, that Baldwin acted unsafely. First, never point a gun at someone unless you intend to shoot them. Baldwin did that. Treat all guns as if they're loaded. Baldwin didn't do that here. And keep your finger off the trigger. And Baldwin broke that rule too. He broke all the rules. And by the way, this is the argument the state's going to make. The state will make against Baldwin in his own manslaughter trial. And again, this would also be an argument towards intervening cause. That but for Baldwin's misconduct, there would have been no harm caused for whatever Hannah Gutierrez had done with the ammo. At worst, it would have been a miss, because the muzzle would not have been pointed directly at Halyna Hutchins. The defense says you'll hear that Baldwin was presenting the revolver using a cross-draw method when rehearsing and when he pointed the revolver. So this would be if you're right-handed, the gun is kind of on your belt on the left-hand side, and you grab the handle and the gun moves across your body like this. Across your body. That's why they call it a cross-draw. The defense argues that a cross-draw is particularly dangerous method of presenting the gun because the muzzle of the handgun can sweep parts of the actor's own body. It could sweep your arm, your left arm, as well as, of course, it could sweep across actors and crew. Gutierrez, the defense says, asked to train Baldwin specifically on this cross draw, but Baldwin did not comply with this request. Now, I will say, I know there's going to be people in the comments saying there's nothing wrong with a cross draw. And I agree. There's nothing wrong with a cross draw if you do it right. But if you do it wrong, you could be doing all the things the defense is indicating here. You could be muzzling yourself. You could be muzzling other people. And that's rather the point here. The point is that Gutierrez tried to prevent it from being done wrong. And it was the production that prevented her from ensuring safety in this regard. It's a pretty quick way to present a pistol too, by the way. Cross draw. All right, so another set of arguments by the defense here that the state's new theory, they call it a relatively new theory on live rounds having identifying characteristics is wrong. And I'll just do this quickly because I talked about it earlier. But the defense says with respect to the ammo, the state has a relatively new theory based on purported differences in appearance between live rounds and dummy rounds. Particularly, the state says that the dummy rounds were characterized by brass with patina. The case had a discoloration and brass colored primers, whereas the live rounds were characterized by shiny brass without patina and by nickel, silver colored primers, which is what the state argued on its opening statement. And I pointed out then that, in fact, you'll hear evidence that there were dummy rounds on set that also had nickel primers. There wasn't only live rounds that had nickel primers. And there's an FBI report that a box of ammo collected from the prop truck had 17 dummy rounds with nickel primers on them. So clearly the state's theory that all nickel primer rounds are live rounds is demonstrably not true. And me speaking now, this undermines several claims by the state in opening that they have these photos showing live rounds in bandoliers and gun belts throughout the production of Rust. I don't believe these rounds were actually inspected and found to be live rounds. I believe the state is merely inferring that they were live rounds based on this claim that nickel primers equals live rounds, which is clearly, as we saw, demonstrably not true. Another argument by the defense is that the ammo that's relevant here, especially the live rounds, was not brought in by Hannah Gutierrez. Remember, that's part of the state's argument, right? One of her forms of negligence was a form of omission, failure to do an act, that is, adequately inspect the ammo in the gun that was ultimately put in Baldwin's hands. The other path of negligence, form of negligence, was an act of commission, that she brought live rounds with her to the set from California. The defense here is arguing that, remember, because the state has to prove that theory beyond a reasonable doubt. And the defense is saying, hey, there's like a ton of reasonable doubt here. So the defense tells the court, the state said in opening that Gutierrez was responsible for sourcing the ammo and firearms on the set. But that's not true, in fact. And we already talked about this. Guns and ammo were sourced primarily from PDQ Props, a company owned by Seth Kenney. Remember Seth Kenney and Thel Reed did the live shooting in Yellowstone 1883 prior to this? And that employed Sarah Zachary. So Sarah Zachary was an employee of PDQ Props, and she was working on the Rust set as the head of props. So in that role, remember, Gutierrez had two jobs: armorer, she was the head armorer, and also assistant props. So she was a subordinate to Sarah Zachary in the context of props. The defense says they're going to hear that Seth Kenney, the owner of PDQ Props, that provided these purported dummy and blank ammo and firearms, real firearms, to the production, and from whom the live rounds could have been sourced. And that Sarah Zachary, who was employed by PDQ on the Rust set, both quickly involved themselves in attempting to influence the investigation to point the finger of responsibility away from themselves. Because what would Seth Kenney's concern be, and Sarah Zachary's concern be? Holy crap, was that live round one of ours? Are we going to be charged with manslaughter? So would it not be in their interest to divert attention from themselves to identify an alternative suspect for having brought the ammo and covering up any evidence that Live ammo might have come from them. So they would have an incentive to do this, a motive to do this, and they would have some opportunity. Seth Kenney wasn't on the set when the shooting occurred, but he quickly got in contact with the sheriff's office to influence their view of the investigation. And Sarah Zachary was on set. She was the props manager. And she did things that certainly qualify as evidence tampering. Sarah Zachary, in particular, had motive and opportunity on the set at and after the date of the shooting to tamper with evidence involving ammo. And indeed, we know she did tamper with evidence because she told investigators she did. Specifically, shortly after the shooting, Sarah Zachary removed rounds from 2 of the actors' guns and throws them away. And they're never seen again. That's evidence tampering, folks. That's evidence tampering. When asked why she threw the rounds away, her answer was she just panicked. Now, of course, and the defense points this out, it's a jury's job to evaluate the credibility of witnesses. If the rounds were dummy rounds, they're still useful. Why would you throw them away? You don't normally throw away dummy rounds. What would you throw away? You would throw away live rounds that could be traced back to you. So if they were live rounds, not sourced. Now, if they were live rounds and Sarah could look at them and say, well, I know these aren't ours, she'd have no motive to throw them away. They're not relevant to her. The only reason to throw them away would be if they were live rounds that could potentially be sourced back to PDQ and Seth Kenney and Sarah Zachary. That's a perfectly reasonable inference to make from this circumstantial evidence and from her conduct. There's also a lot of problems with the broken chain of custody of the ammo box. This is the box that Gutierrez was using to load Baldwin's pistol, the one in which one live round was found when the box was inspected back at the sheriff's office. But that box was initially supposedly found on the ammo cart, and then it was put in a sheriff's office vehicle, and then it was put back on the ammo cart so it could be photographed on the ammo cart as if the photograph represents the original finding of the box on the cart. But and the ammo cart, while the box was on it, was at the very edge of the crime scene tape. And we know that people were reaching over the crime scene tape and accessing items on the table. The sheriff's deputy who was there remarkably insisted that while he was wandering around talking to different people, that he was also constantly keeping full vigil observation of the ammo cart. At one point, he claimed that his body was turned 180 degrees away from the ammo cart, and yet his head was rotated 180 degrees, still looking at the ammo cart. He said, well, you know, my body camera looks in a different direction than my head turns. Nobody's head turns 180 degrees, folks. So if there were any moments when that cart was not under observation, there's no way to know if that live round was put into the box as evidence tampering after the shooting to implicate Hannah Gutierrez. We just can't know. The cart was not immediately seized by police. It was brought over to the police by some crew member we know who that is. They know who it is. I haven't heard them identified yet. Could that have been Sarah Zachary? Someone with a motive and opportunity to point the finger away from herself and at someone else? Then there's this issue about the fact that Thel Reed had an identical ammo box to that ammo box we're talking about, the one that Gutierrez was using to load Baldwin's gun. And we already talked through the fact, I'll just skip over this really, that Thel Reed and Seth Kenney had both been doing a live fire training for Yellowstone 1883. Thel had brought his live ammo to that live fire training, which is perfectly appropriate. And some of that ammo we know found its way back home with Seth Kenney because it was found in his place. And then Seth Kenney provided ammo, supposedly dummy and blank rounds, to the set of Rust. Is it possible that unintentionally some of the ammo provided to the set of Rust was the Thel Reed ammo that Seth Kenney had brought home? So the Thel Reed ammo got to the set not through Hannah Gutierrez, but through Seth Kenney? Maybe Seth Kenney was concerned about this implication? There is a little more detail here. So it turns out that the Thel Reed ammo that was used at Yellowstone 1883, the rounds that were labeled Yellowstone 1883 and found at Seth Kenney's place had a blue coloring to them. And the rounds found in the bandoliers and belts that were live rounds also had that blue coloring. So that allows for a solid inference of reasonable doubt that it was Hannah Gutierrez who brought the ammo to the site. The defense also made quite a bit out of a particular kind of dummy round. So there's a dummy round called a Denix round. Apparently they're from Spain. And it's a round that's visually indistinguishable from a live round. So there's no hole drilled in it. There's no BBs or springs in it. And it's got a primer. Now, it's not supposed to have any gunpowder in it. And maybe the primer is supposed to be dead. But just looking at it or looking at a photograph of it, it's indistinguishable from a live round. Now, there were only one of these on set. And I think the defense is talking about it because it's dangerous to have this on set. You shouldn't be doing that. But I'm not sure how much it helps them, because the truth is, if you're looking at a round on set and you can't distinguish it from a live round, what's the only safe fallback position? To treat it like a live round. So you should throw it away just like you would throw away a live round. It doesn't matter that it would, if inspected closely, if pulled apart, it would turn out to be one of these Denix rounds. It just goes in the trash. You wouldn't keep it on set. So that argument, except I guess I might attribute to a broader narrative of the production being poorly organized and poor safety generally and that kind of thing. All right, the conclusion for the defense: Gutierrez had insufficient time to do her armorer duties because she was also forced to do props, and management made a number of mistakes and did not create the proper safety atmosphere. Rush Production and the state want to scapegoat her. She's not guilty of the crimes charged against her, and the prosecution must prove that, not that she's not guilty, they must prove her guilty beyond a reasonable doubt. The defense submits they will not in this trial for the reasons I talked about in opening and the evidence that you will see. And that is all of that. So I think the defense has some good arguments. I don't think it's as lockstep in argument for involuntary manslaughter in the case of Hannah Gutierrez as someone like me on an initial take, someone with a zero tolerance policy for gun safety would lean to. And that's certainly where I did lean to. But remember, the jury's not me. And she is a young woman. You'll notice, by the way, in the courtroom, they've made her up to be a much more attractive young woman than she was on the set of Rust, right? She looks almost normal, except for the weird eye makeup. And that's part of it. That's going to be part of the emotional argument the defense is going to make to the jury. This is a young woman, naive, powerless, doing her best, set up for failure. Failure happened. It's not the fault of the people who set her up for failure. All these millionaires, these directors, even her superior in the props department, the things she had no control over, like the provision of the ammo from PDQ, the guns from PDQ, she had no control over. The safety training she wanted to do. She wasn't allowed in the church with Alec Baldwin. If she had been, she would have done the detailed review of the gun with him in person. There's arguments to be made here. All right. Let's see what we've got in terms of law of self-defense member questions. Don't forget, folks, you can become a member for 99 cents. Join the family. Join the law of self-defense family. That's the only way you get your questions and comments addressed. 2-week trial membership for 99 cents at lawofselfdefense.com/trial. After the 2 weeks, membership is still dirt cheap. It's only about 30 cents a day, less than $10 a month to be a Law of Self-Defense member, folks. And by the way, these 2 PDF documents we looked through, those will be embedded in the members only playback version of today's show for any Law of Self-Defense member who would like those. Let's see. Too many H's. Yeah, I see lots of people tripping over Hannah Gutierrez and Halyna Hutchins. I usually catch myself right away, but all those H's, it's tough to avoid. Michael says, if the state intends to show that Gutierrez cocaine was evidence, it can only be evidence of impairment negligence. The failure to drug test her looms large. Again, they didn't know about the cocaine for a long time. until well into the investigation. And then the judge agreed with the defense that testing at that late a date would not be relevant. I mean, maybe she just started using cocaine after the event because of the stress she was under. Who knows? D says, during IDPA type competition, we would often mark the head of the brass with a permanent marker so we could recover our own brass for reloading. I couldn't trust anyone else's brass as I didn't know how many times it had been used. Yes. So I'm trying to think if I would. My practice was actually, it was a little more costly. So I would tend to use nickel brass instead of brass. And so most people don't, nickel is more expensive. So most people for high volume reloading would just use brass. And I always picked up my brass right after I shot. Most of us did. Where I shot, it was our practice each shooter would pick up their brass right after they shot. So there generally wasn't a big and we were all reloaders. So there generally wasn't a big accumulation of brass on the ground where you had to find yours. It was just whatever rounds had just been fired. But yes, it's nice to get your own brass back. I mean, I've reloaded 45 ACP and fired it and reloaded it and fired it and reloaded it so many times that you couldn't see the head stamp anymore. And it worked fine. I never had a problem with the 45 case. They would sometimes when you tumbled them, when you inspected them afterwards, you'd find one with a crack forming at the case mouth. And of course, those you would throw away, but they lasted a long time. 40 Smith & Wesson brass, forget it. That's why I gave up shooting 40 Smith & Wesson, because that brass deformed after a couple reloads. It would get this like belted magnum belt around the case head. It was terrible. And a normal Dillon 650 XL would not resize that magnum belt effect. Let's see. Kyle says they have a huge chasm to cross to convince me that was tampering with evidence. I think it all depends on whether you believe it's cocaine. If you believe it's cocaine, then it's a logical inference that she was tampering by trying to get rid of the cocaine so it would not be discovered as evidence. The hesitancy would be, are you willing to agree that it was cocaine beyond a reasonable doubt based on the mere description, a bag of white powder? I don't know. That would be tough for me. All right, folks. I think that is it. I think that is it for today. So those are all the questions I have from the Law of Self-Defense membership. Thank you so much for joining me on a Saturday. There's a lot more detail in this case to cover. I might do a show tomorrow on it, particularly some of the motions that happened pre-trial that I think are pretty funny. And I wish I could do end of day summaries. I don't know how I'm going to find the time to do that. I have to be honest. But if I can, I will. And certainly if something particularly exciting happens, I'll be sure to call that out in my coverage of the trial. But I do plan for sure to be streaming the trial live again on Monday, starting 10:30 a.m. Eastern time. I'll send out an email about that to all of you. And that's about it. So I remind all of you, if you carry a gun, so you're hard to kill. That's why I carry a gun. So I'm hard to kill. So my family is hard to kill. That's why I carry a knife. It's why I carry OC spray. It's why I study jujitsu. So I'm hard to kill. So my family is hard to kill. If you do any or all those things for the same reason, so you and your family are hard to kill, then you also owe it to yourself and your family to make sure you know the law, so you're hard to convict as well. Until the next time, maybe tomorrow, definitely Monday, if not tomorrow, I remain Attorney Andrew Branca for the Law of Self-Defense. Have a great rest of your weekend.